everyone. Thank you very much for your presence. This panel will discuss the right to access of data subjects to police data. It's a subject that is coming back and back and back in all occurrences of the CPDP, but there are some news and interesting news on the topic, and therefore we thought it was interesting to organize a panel on this topic. So as you might know, the right to access is in general a fundamental right guaranteed by Article 8 of the EU Charter. It's a fundamental right. There are of course exemptions that could exist, certainly in the case of police data, because of course police forces need to be able to do their job. So today we will discuss two different things. We will discuss access rights of data subjects to national police databases. That's what Catherine and Stergios will talk about. Catherine will speak us about the directive, the law enforcement directive, which is the equivalent of the GDPR, but in the police context. And she will then present the Belgian system and the French system of access to the data. Then Stergios will present us the system in Cyprus and in Greece. And then we will of course talk about Europol. We have the pleasure to have Daniel here, which is the DPO of Europol. And then the EDPS will talk us about, Joanna will talk us about the supervision of Europol. That's a bit the idea of our panel today. I will briefly present each of the speakers if it's necessary. Well, Catherine is a lawyer at the Brussels bar, and she specializes in data protection law. She's also an assistant in criminal law and procedural law at the University of Saint-Louis. She's also a member of the research group on criminal law and procedure known as GREPEC. Stergios is a Greek lawyer that specializes in data protection as well and intellectual property. He studied in Belgium, Cyprus, and Greece. He was a trainee at NOIB at the European Commission. He is now DPO for several stakeholders of the public sector. And he's also a member of Homo Digitalis, which is an NGO in Greece. Daniel, as I said, is the data protection officer at Europol. Thank you very much for being here. He is also the founder of the Europol Data Protection Expert Network, EDEN, and member of the CPOL Expert Group on Fundamental Rights. And Joanna is the legal officer in the Supervision and Enforcement Unit of the EDPS, and she's based in the sector for supervision in the area of freedom, security, and justice at the EDPS. Thank you very much, all of you, for being there, and I'll give the floor directly now to Catherine to speak us about the system of the directive, and then to compare the national systems in Belgium and France. Thank you very much, Catherine.
Thank you. It's a little bit strange. Okay. Thank you, Franck. Thank you, Franck, for the organization of this panel. Before that I begin, I just will excuse me for my English. I do a lot of mistakes, but if you don't understand what I say, I made slides and you can read, and so you will understand what I will say. So, as Franck say, right to access is a fundamental right, but above all, right to access is also the first middle for the people to know what the police and if the police process data about her. If the data subject don't have an access, they can exert another right, like the right to ask to modify the data, to delete the data, to contest the validity of the data, the legality of the data. So the right to access is the first right before the another right, and it's why it's a fundamental right, but also a very important right. Right to access is guaranteed by the directive police, and I will present you two examples of transposition of this right in Belgian law and in France. So following the directive police is the right to access, not only the right to access to the data, but it's also the right to know if the police have data about the data subject. The right to access is also the right to receive information about the process, like the purpose and the legal basis of the processing, the category of the personal data, the duration of the conservation of the data, etc., etc. You can read it. There are a lot of information that the data controller have to give to the data subject if they ask it. But this right is not absolute. Article 15.1 of the directive say that this right can be restricting, partially or totally, and it's the same thing. It is the same than Article 52 of the Charter. The member states have to make the limitation with a legislative measure. The legislative measure has to be necessary, proportionate, and to pursue a legitimate aim. In case of limitation, the directive provides certain safeguards. So the reason of the limitation has to be right, and the reason of the limitation has to be available for the supervisory authority. In case of limitation, the member state can provide that the right has also to be exercised by the supervisory authority. If the data subject has to go to the supervisory authority, the supervisory authority can at least answer that he made all the necessary verification. And the supervisory authority has to inform the data subject of the possibility to make a judicial remedy. In Belgian law, so it's an example of the transposition of the directive police. In Belgian law, you don't have an access by the data controller. So Article 14 doesn't exist. You have to go directly by the supervisory authority. But the Belgian legislator forgot some sentences of the Article 15. So it's not only in case of restriction that the data subject has to go to the supervisory authority. So it's the organe de contrôle de l'information policière, the COC, I will say the COC. So it's not only in case of restriction that the data subject has to go to the COC, but it's always. And the COC answer, not at least, but always, that he made all the verification. So Belgian just forget the word at least, and the supervisory authority answer systematic, we made all the verification. And it don't inform the people that they have the right to go by a judge. So officially, there is no judicial remedy against the decision of the supervisory authority. So it means different things. The good thing is that the people don't have to look who are the data controller, because in Belgium there are more than 1,000 data banks, so there are more than 1,000 data controllers. So it's impossible for the people to exercise their right, because they don't know who is the data controller. So it's a good thing. You go just by the supervisory authority, and they will do what they have to do, but it's impossible for the people to contest the data because they don't know which data the police has. So l'organe de contrôle did do a control, but we don't know which control and how they can make it, because they don't have information, because the people don't have information. So the bad thing is that they can't obtain information about the processing, and they can contest. They don't have a right to contest or to ask to delete the data because they don't know what they have. So it's impossible to exercise the right for the people in Belgium. And it's a problem with the directive, but also with the fundamental right, because it's a systematic limitation of a fundamental right, and it's against Article 52 of the Charter. There is also no formal judicial remedy. So we did in one case a judicial remedy, but it was a little bit not official, the good procedure, just because we took a procedure in another system, SWAT. There is also no formal judicial remedy because Belgians say that it's not a legally binding decision. They say the supervisory authority will just exercise the rights on behalf of the data subject, and they give a recommendation to the police. So they say it's just a recommendation. So it's not necessary to provide a judicial remedy because there is no effect for the right of the people. But it's not true because in practice, a supervisory authority will verify if the processing is lawful, and it will verify if the restriction of the access is legal. So what Belgians say, it's not correct. You have to, if you read the directive, you have to foresee a judicial remedy against the decision of the supervisory authority because it's a legal binding decision. In French law, it's an example of good practice because you have a direct access by the data controller, so you can ask to the minister or the data subject can ask to the minister to receive the data, to have an access to the data, to receive information about the data, except in case of the data concern national security, like terrorism or national security. And if you don't have an access to the data or if the data controller didn't answer or if the data controller didn't give an access, you can go by the supervisory authority. It's the CNIL. But there is a little problem. There are no judicial review or remedy against the decision of the CNIL. And France have the same answer than Belgium. They say, no, it's not a legal binding decision. We just exercise the right on the behalf of the data subjects, so it's not necessary to provide a judicial review. As I said, there is a case now by the European Court of Justice, so we will see what they will answer. The true question was, can the supervisory authority systematic answer that he made all the verification, or it's only in case it have to be proportional? And the second question was, it's necessary to provide a judicial review against the decision of the supervisory authority or not. So we will see, maybe in 6 months we will have the answer. Thank you.
Thank you very much, Catherine. It's also good to know that the pending decision in front of the ECJ, well, it's pending for the moment, but we will have the conclusions of the Avocat Général in June, so pretty soon. I was personally at the audience and we heard the comments of the Commission and the EU Parliament, so the ones that drafted actually Directive Police and Law Enforcement. And I would say that they were pretty clear about the fact that the Belgian system was not okay with the directive. But we will see and wait for the conclusions. Thank you very much, Catherine, and I'll give the floor now to Stergios.
Hello, everyone. Thank you for having me here today. We're going to, following up this great presentation, we're going to see what's the Hellenic approach, in particular in Greece and in Cyprus, which is quite interesting, especially in Greece, because I don't know if you're aware, the last year was we had an issue about monitoring of political parties, leaders of political parties via spyware. You know, it was a very interesting period in Greece and a very relative thing, the right of access to public authorities, databases, and police, for that matter. So first and foremost, who are we? I'm here representing Homo Digitalis. We were founded in 2018. We are headquartered in Athens, and we are active in Hellas and in Europe in general. We have a network of 120 plus volunteers who now, at least for now, we are based on our volunteers. We do not have people with Homo Digitalis does not employ people to work. It is a collaborative effort from many individuals. So far, we are the only digital rights organization. As I said, we work on a voluntary basis. We are full member of EDRI. We are member observer in committees of council. We cooperate with UN special rapporteurs. We communicate with universities. We contribute to papers. And we have gender equality. And we have internal policies prohibiting discriminations. We are open to new ideas and so on and so forth. So, right of access. So in general, just I'm sure all of you are aware, just a quick introduction so we can all be on the same page. It's a fundamental right, as it was said earlier, that gives the data subject the opportunity to have a confirmation on the process of its data and learn about the purposes, learn about which categories are processed, what's the origin, the recipients. Recently, we had a very interesting decision by the Court of Justice of the European Union and clarified what recipients mean when we have a right of access. And I believe that goes to the right of access for under the LED Directive as well. You provide the full list of the recipients and details. Data retention period, rights, as well as rights where if you can file a complaint, you can get a copy in a human readable form. And the restriction is the rights and freedoms of others. That's the rights of freedoms, the right to data protection. It can be the right to data protection of others, or it can be the intellectual property rights of third parties. Now, the right of access under the LED Directive, it was explained earlier. I'm just going to set it out. It's, again, the same in practice logic. Okay, we have to know about the origin, the rights, data protection, data retention period. But it's interesting to see how the member states, and in particular Greece and Cyprus, implemented this specific obligation for data subjects. We have some limitations, which is important to keep in mind, because we have to see the difference for the limitations that the LED Directive foresees and the limitations that each government stated. So we have partial or complete restriction to the access right if it is necessary, proportionate measure in a democratic society with due regard to fundamental rights and legitimate interests of natural persons. The scope, the goal is to avoid obstructing official or legal inquiries, to avoid prejudicing the prevention, detection of serious criminal offences, protect public security, protect national security, protect rights and freedoms of others. It's pretty clear. So we can restrict the right of access in order to achieve those goals. And here goes the interesting part, the Greek approach. So we have the right of access. It's foreseen that we can access to what are the categories of personal data, what's the origin, purposes and legal base, retention period and rights. So far we're good. And then we change the article and go to limitations. So the first one, which was very interesting reading it was like, for the X, we cannot, actually, a competent authority, to help everyone be on the same page, a competent authority is the police. Okay, can restrict the right of access if it's in the context of their exercises as competent authorities. So practically all the processing operations that the Hellenic police, for example, does in its context of duties, they can say you do not have the right to access to your data. And it's foreseen in the law. Yeah, especially now it was really interesting because, you know, Reading it, it was like, because I'm also I'm acting as a DPO for many institutions and political parties, and I was trying to see what options do we have in case that it might be required, and we bumped into this exemption. So police can say no, just no. If you want as an employee, be my guest, but if you want as someone we conducted investigation to you, we can say no. So for national and public security, so not only you cannot access what process do I do if I'm conducting an investigation, legal or not, but also you cannot access to the data I collect through the cameras. So no files, no cameras, and for the protection of legitimate interests of third parties. So practically the law said no right of access for you, for competent authorities. Good luck fighting it in the future. Unfortunately, it had... and then a second set of restrictions is that cannot be erased due to legal obligations. Usually is the limitation period in Greece. It's 20 years, pop, everyone. When we come to retention periods, 20 years, 20 years, 20 years. It's very broad used. The second is we cannot grant access to data that serve only, and that's, the translation is mine, so forgive me for any mistakes, but it was direct. We cannot access data that serve only for data security purposes. So if my data can provide data security for the Hellenic police, that can be, or anyone's data, right? It's pretty crazy. And data that serve only data protection controls, where the provision of information would involve disproportionate effort and processing for other purposes through appropriate technical and organizational measures is excluded. There is some ambiguity, one would say, in the exceptions. Also, if the provided information this is okay, their life or physical integrity of others. However, the Hellenic police must provide the response in writing. And of course, the remedy is that the data subject can go file a complaint before the Hellenic DPA, and the Hellenic DPA can facilitate the access, order the access. However, legally per se, as we saw earlier, even the Hellenic DPA, I'm not sure what's the competence of instructing the Hellenic police according to law to give access to those files. Now, the Cypriotic approach, in principle, it can do the same, but the exceptions are specific and are very interesting. Cyprus implemented two laws regarding data protection, the one which specifies the GDPR in 2018, and the second which implements the directive in 2019. Okay? And it says that first, personal data held in official documents can be accessed through the public sector access to documents way, the access of documents legal way. Now, restriction to access is to avoid obstructing legal inquiries, to avoid obstructing prevention of serious crimes, protection of public security, protection of national security, protection of the rights of freedoms. Mainly Cyprus followed the directive. Greece, on the other hand, that's why I said in the beginning, it's really interesting to check it. Greece said, okay, what the directive says, let's take the other road. They don't know what they're writing, okay? Now, what were our actions to that regard? So, in Greece, I believe not only in Greece, but police is competent for the issuing of passports, right? So, the Hellenic police stored all the fingerprints of the Greek citizens in their databases. However, the law stated that the fingerprint as a biometric data were stored within the passport, not on the database. And it makes no sense, okay? So we filed two strategic complaints and before the Hellenic DPA. Unfortunately, it hasn't been yet any decision out. It's still under investigation. But we're confident that some good will come out of it. Thank you very much for your time, and whatever questions you have, maybe later on. Yeah. Thank you very much.
Thank you very much, Stergios. It was really interesting to see the differences between the Belgian, the French, the Greek and the Cyprus approaches in their national systems about access, direct access, but also the competences of the supervisory authorities in all these systems. We will now change a bit of topic and speak at European level about Europol. We have the pleasure, as I said, to have here the DPO of Europol, Daniel, will speak us about his role as a DPO at Europol and about the requests that he receives there.
Thank you. Thank you, Frank. Thanks for the invitation by the Vrije Universiteit Brussels to speak on this topic here. As Frank said, I'm data protection officer at Europol, and what I would like to do is, because I understood that this should be more or less a workshop, I will, in my presentation, do two things. The first one is, I will do that what I learned as a data protection officer for many years, that if you're in a room and there's an elephant in the room, just point out what is the elephant, and not avoiding the elephant. And the second one is, I would like to go with you through a practical case, actually, how we handle data subject access requests at Europol. I mean, Europol is, as Frank said, or introduced, is maybe a bit of different topic. So it's not just Europol receiving data subject access requests in the European Union, and we have our specific regime, and I'm grateful for the possibility to present this to you. The elephant in the room is the following, and that is also what we heard now from the previous two speakers. Police, in general, is reluctant to share operational data outside of the investigations. This has nothing to do specifically with data subject access requests. It has simply to do, even if there are requests from other state authorities towards the police to receive data out of operational files, the first reaction of the police officer will be, I have to safeguard my investigation, I don't want to share. I think that is the elephant in the room. On the other side, we have, and that two speakers, previous speakers clearly outlined that, we have this fundamental right of access to data that is held by the police, by citizens. And what I will do now in my presentation, I will give you a bit the overview of that, how we at Europol live up to this fundamental rights of access by citizens. How does this work?
Just click on it.
On the green? On this one?
Yeah.
Okay. Good. So just very few words about Europol. Europol became operational in 1999. The Europol is the European law enforcement agency based in The Hague. We have working with us for the support of the national law enforcement authorities in the fight against organized crime and terrorism. More than 130 analysts, police data analysts that work on files that we hold on behalf of member states, because most of the information stems from member states. There's also part that stems from third states, but most of the police information that we receive at Europol comes from member states. It's a bit more than 1,400 staff members in The Hague, and we have with us 268 liaison officers from member states and third states that join us in The Hague for police cooperation. And just to give you one last number, if you look at the Europol information system, we have in the Europol information system now around 1.4 million data sets. Data sets that is not all personal data, but these are data items in the Europol information system. I'm happy to take questions later. Okay, that's good. That's a nice one. Now you saw all my presentation already. Okay, but this is important. When I started at Europol in 2003, I remember it, we had 13 data subject access requests, 13, 1-3. And that is, I don't know why this moves automatically.
I think it's not me.
Somebody hacked the system. How can I stop this? Okay, because I want to show you this here. So from this 13, now you give me the sign if this moves again. Yeah? So from this 13 requests, there was one person that was very, very concerned. And at that time, we had the Europol director Storbeck, and here it moves again.
It's the police.
Yeah, I think so. Somebody hacked the system. So he approached Europol. He was really concerned because he was 100% convinced that Europol had his data. And we wrote back to him, and that was one of the first data subject access requests also for us, so we had to learn a bit. And at a certain moment, when I presented that I was not yet data protection officer, but when I presented this to the Europol director, he said, well, we have to recognize that this citizen is very much concerned and really believes that we are after him. Can't you ask him to meet me when I'm the next time in Brussels, because he was a Belgian citizen, to meet me, and I'm ready to talk with him. And that is actually this photo that I wanted to show you. Now it doesn't work at all anymore. Sabotage. He met him actually in the early morning in a park here in Brussels and explained to him, of course, the citizen was a bit paranoia regarding police, and said to him personally, we don't have anything about you. And the citizen afterwards didn't approach us anymore because he then was satisfied because he got this personal communication with the Europol director. And I think that is important because first of all, that's crazy. First of all, I think it is important that how good you are in data subject access request is actually a matter of public trust as well that you shape. Yeah. So the citizen asking for the police to personal data is at the end a litmus test for democracy. Ask now as a Russian citizen to the Russian police for access to your personal data. You will find most likely a completely different situation in the European Union, even including the cases that were presented before here. Now we come to this, because we are not anymore with 13 requests, we have now stable 500 requests per year at Europol. That's basically the difference between the Titanic and a cruise ship of nowadays. Important there, and here I would come to the different stuff. Just completely crazy. Important is that this data subject access requests at Europol, they are handled by the Data Protection Office. That if you look at the Europol regulation, there's nowhere written that the Data Protection Officer should handle the data subject access requests. In my opinion, it is important. My agency took the decision a long time ago that these requests are handled by the Data Protection Office. It is, in my opinion, an additional data protection safeguard that you will not find in the legal framework. And if I talk about 500 requests, and we have growing numbers, and we have also growing numbers of hits in the system on the basis of the request, that is quite some work that my office does in checking the systems. And now I would like to go forward. Let's see if, okay. In checking the systems at Europol, and to give you an idea, it's 1.5 full-time equivalents that we spend for checking the systems and for answering citizen requests. Once again, we have a stable number of 500 requests per year, and I don't think that will massively change, but this is what we calculate actually for when we come for the planning of the resources. So here I put for you 6 steps when it comes to the handling of data subject access requests. First of all, as I said, the requests are handled by the Data Protection Office, which is here called the Data Protection Function, because we are an independent office at Europol. So we report not to the executive director, but we report to the chairman of the management board. And what was presented already before by Catherine, basically the principles that are enshrined in the Charter, but also in the Law Enforcement Directive, and I have another slide on this, that apply to Europol are the same, which means it's not like that only EU citizens can ask for access. We get data subject access requests from around the world. It is of course free of charge. Yeah? So you will not find a clause in the Europol regulation that says, well, and if you ask 4 times per week, then you have to pay. It's not foreseen. It is independent from nationality. It is important that the citizen approaches Europol and says, he or she says, I would like to have access to my data. That is sometimes not so easy because we get letters from citizens where you have to try to understand what actually the citizen wants. And that is, by the way, also when we get requests that law firms make on behalf of their clients. Also there we sometimes struggle to see, is this now a public access request or is this a data subject access request? But once again, the advice and the guidance to the agency is done then by my office. We look at it and we try to understand what the citizen really wants, because we believe that this is important, that every citizen gets within 3 months, that is foreseen by the EU regulation, the answer. We had a change in our regulation last June, and since last June, the EU regulation foresees that the citizen can approach directly Europol. So what we have now in this 500 requests, they are partly coming via national authorities still. So if you go to the Europol website, you will have a list of competent authorities that you can approach. And via these competent authorities, you can send your request to Europol, but you can also send the request directly to Europol. And we get the request from via various units, via various email addresses. They're all end on the table of the data protection officer and are then treated accordingly. Which means, and that is here this overview, so we receive the request, we do a verification of the data subject access request. We are not looking at whether camera pictures are asked or else. It's just about, I want to know whether you have something about me in the system. Then we check the systems. And that is actually the major part of the work. Go through all the systems and doing the checks on this specific name of the citizen that are asked for access. Then we divide the cases actually, because there are cases in which data is available and there are other cases there's no data available. Long time at Europol ago, there was a discussion with the supervision, the former supervision actually, whether if we have a situation where there's no data in the system, whether we can give to the citizen a straightforward answer and say, there is no data about you in the system. This discussion is now history. If there's nothing in the system, the citizen gets a clear response as soon as possible. We don't have any information about you in our system. And I think that is very important because there is the need that the citizen is at ease and gets this information in very clear language as soon as possible. The checks in the Europol system are not done by the police officers at Europol. The checks in the Europol systems are done by my office. And that is also, in my opinion, also again an additional data protection safeguard, because if you would ask an operational unit to do the checks, they might say, yes, we do the checks, but we could also look a bit into the surrounding of this check and see, I don't know, in which databases, in other databases this information might be. And therefore, I think it's important that these checks are done by authorized officials that are outside actually of the operational activities. From a data protection point of view, I think important point to mention. I said that we divide the cases then into the no information, a clear answer to the data subject, to the citizen. If there's information, Europol has an obligation, according to its legal framework, to go through consultation procedure. Consultation procedure means that Europol has actually, since the data is stored at Europol, not under Europol's responsibility, but still under member states' responsibility, has to consult all member states that are somehow related to the data, plus the data provider. It's a condition in the Europol regulation, so that is what we do. And I think I can show you also a slide later. Oh no, I'm just going to this slide. Yeah, so this is basically the case, and then we can move back to the other slide. So this is basically the case. What we here, this is of course fiction. What we have here is we have a data subject access request, and it turns out that the data subject that asks for access is with his first name, last name in one of the analytical projects for outlaw motorcycle gangs. And this information was initially provided by Germany. The same name we find in an analytical project on racism and xenophobia. And this information was provided by Spain. And we also find this data connected to an offense in drug trafficking. And this information is provided by third states, so by Albania. Which means that according to our rules, before, I try to go back, before we reach the stage where the director takes a decision whether to grant access or not to the citizen, and she does this on the basis of an assessment that the data protection officer provides her, we have to go through a consultation process. And that means that we have to ask all the data providers that you see here in this specific case, whether they allow, and that is important. The question that we ask is, can we provide this personal data to the citizen? Because our approach is, a citizen asks for access to his and her data, by default, the citizen should get access. So our question to Germany, Spain, and Albania is actually, do you allow that we found this information? Do you allow that this information is provided to the data subject and to the citizen? And after we received all this feedback, and then you see here Germany and Spain as EU member states, but Albania as a third state, we then provide the file to the executive director to take a decision whether she can provide access to the information or whether she has to reject the access to the information. It is basically one of the very few decisions by the executive director of Europol that has a direct impact on only one person. I don't think that there are a lot of, I mean, of course, there's staff matter decisions that she takes, but I think this is really just, she takes the decision, it has an impact only on one person. I put here on this slide, but the previous speaker already outlined this perfectly. On the one side, the law enforcement directive, on the other side, the EU DPR. That is actually not only applied to Europol, but the EU DPR is applied to all EU agencies and institutions, so Frontex, EU-LISA, Eurojust, they all also receive data subject access requests, but indeed Europol seems to be a leading agency, as what I understood, that we have more than 500 requests per year. And there, if you compare the two legal texts, so Article 14 of the Law Enforcement Directive and the EU DPR, you will see that Europol has not more flexibility. We have actually the same limitations that are in the Law Enforcement Directive, and you see it here in the EU DPR, and then the link is to Article 36 of the Europol regulation. Because if you read Article 36 of the Europol regulation, there's a link to then Article 81 of the EU DPR 2018-7025. I'm coming nearly to close of my presentation. So this here you see once in the cycle the consultation procedure that we have. So we have to ask Germany, Spain, Albania. Then we also ask our operational colleagues for input to the file because there might be other information still connected that we were not aware of when we previously checked that information. And at the end, there's then the decision of the Europol director on the basis of the checks that we do. And there, I'm going back to this slide. There we apply the principle that you also saw in the Law Enforcement Directive. consider whether restrictions to the provision of information apply, and if yes, whether they constitute a necessary and proportionate measure in a democratic society with due regard for the fundamental rights and legitimate interest of the natural persons concerned. So this assessment actually you find in the file that goes to the executive director with all the statements that are made by the data provider and by the EU member state. So if we go through all this procedure, then at the end we have the decision by the executive director. I'm coming to the end of my presentation there. I just wanted to tell you what is also important in this regard is, of course, for Europol, we don't need to know, and we don't even want to know whether a citizen had already an access on national level. We don't need to know this. But what is sometimes necessary, and that is actually what we do with the data protection officers of the national police, that we are regularly talking about practices on national level to see where we are actually in the practice that we had at Europol and on national level, and discuss these practices, also providing training on the handling of data subject access requests. We do this also on the Eden conference, that is together with a meeting of the data protection officers of all EU law enforcement authorities that will meet the next time in Madrid, 18th and 19th of September. And data subject access requests will be again on the program foreseen because it is such an important topic. Thanks a lot.
Thank you very much, Daniel. I'll directly give the floor now to the supervisory authority of Europol, the EDPS. Thank you very much, Joanna.
Thank you, Frank, for organising this panel. I don't have slides, so I hope you'll be able to follow me. I'll try to be as clear as possible, but I think my comments will complement and build on a bit on what you've already heard from the other three speakers. And what I'll try to do is give the perspective of a supervisory authority when it comes to supervising access to police databases, and I'm going to draw on the EDPS's experience in supervising Europol in particular, and on our practical day-to-day experience in performing that task. So a quick word on the EDPS. We are the independent supervisory authority for the EU institutions, agencies and bodies. And the sector in which I'm based, the area of freedom, security and justice sector, focuses specifically on supervising EU agencies that are active in the justice and home affairs domain. So it's Europol, but it's also Frontex, Eurojust, the EPPO, and the EU Asylum Agency. And although that several of those agencies do process what we call operational personal data, so that's personal data that's processed for purposes of judicial and criminal cooperation, I will focus my remarks on Europol because I think it's the most relevant for the topic of this panel. It's also where the EDPS has accrued the most experience on this area because, in fact, to date, we have not received a complaint from a data subject regarding restrictions on access from one of those other agencies. So, what is the role of the EDPS in supervising the right of access as regards Europol? So under the EU legislative framework governing the EDPS's supervision of Europol, so that's the Europol regulation, and it's also complemented by Chapter 9 of the EU Data Protection Regulation, which Daniel just alluded to earlier. Under this framework, if a data subject has approached Europol and has, with an access request, and has had that access request refused or restricted, they may come to the EDPS either by lodging a complaint, contesting or questioning that restriction, or they can request indirect access under Article 84 of Chapter 9 of the EU Data Protection Regulation. And maybe it's just worth mentioning that Article 84 on indirect access, the wording is almost identical to Article 17 of the Law Enforcement Directive. We have not received yet a request under Article 84 for various reasons, also because it's relatively newly applicable to Europol. So just to say a quick word about the role of this remedy that's available to data subjects, and I think Catherine already said something on this, but I think this remedy is particularly important in a law enforcement context, precisely because the potential of the right of access to function as a tool for data subjects to increase transparency regarding the processing of their personal data, to act as a tool for data subject empowerment, to make those checks on the accuracy or the lawfulness of the processing of their data. This possibility is much reduced due to the increased likelihood that restrictions will apply for very valid reasons of national security, public order, and so on, to avoid prejudicing a criminal investigation. And so the role of the supervisory authority to be able to step in and act in a way as a proxy on behalf of the data subject to make those lawfulness checks, to review the validity of that restriction, becomes particularly important. So going a little bit, and just to say also, I think, as a supervisor, it also has a very important supervisory function. I mean, for the EDPS, the investigation of complaints is also a way to detect certain compliance issues that might also go beneath the radar, that might go undetected, especially in an accountability-based framework in which we're working. So that's a kind of, say, an ancillary or secondary benefit of this remedy. So Daniel gave a flavour of the increase in the number of data subject access requests that Europol has been receiving. It's been fairly steep. The EDPS has been supervising Europol since 2017, and we have also seen a steady increase in complaints that we've received, but I would say it remains at fairly low levels, especially given the quantity of access requests that Europol receives. So per year, it's rather in the tens as opposed to the hundreds. So how does the EDPS go about investigating a complaint involving a restriction of access by Europol? I would say there's three essential obligations on the EDPS in this kind of complaint investigation under the legal framework. So the first is to review whether the restriction applied is in accordance with the law. And in fact, Daniel already demonstrated for me that the wording of the restrictions under Chapter 9 of the EDPR, Article 81, and the wording of the restrictions in Article 15 of the Law Enforcement Directive are near identical. And they're also worded pretty broadly, I would say. So, the interests are to, the security, national security of a member state, public order, to avoid prejudicing a criminal investigation. And so I think this increases the onus on a supervisory authority to ensure that and to verify that the restrictions have been interpreted and applied according to a strict necessity and proportionality test. Then second, the second task is to verify that the data is processed in accordance with the law. And this is a specific obligation on the EDPS under Article 47.3 of the Europol regulation. And I think it could be understood in a way as mirroring the requirement under Article 17 of the Law Enforcement Directive to carry out all necessary verifications. And in terms of the scope of these checks, this is neither in the Law Enforcement Directive nor in the Europol regulation defined what this should be. And so it's left to the supervisory authority to determine what the scope of those checks should be. However, I think if we understand that the role of the supervisory authority in this context is to act as a proxy for the data subject, then it could be contended that, as a minimum, the supervisory authority should be checking at least all of those informational elements that are listed under the article on the right of access. So that means not only checking the personal data in question, but also looking at the legal basis for the processing, the purpose of the processing, the storage period, the recipients, and so on. And in terms of checking the data itself, this is something that the EDPS does on the spot by going to The Hague, going to Europol's premises and verifying the data. And then the third requirement of the EDPS is to consult the National Data Protection Authority of the member state that provided the data. And I think this is the key specificity that distinguishes an EDPS investigation of this nature as compared to a National Data Protection Authority. And this stems from the fact that very often when an individual is trying to get access to their personal data processed by Europol, that data will have been provided to Europol, as Daniel explained, often by the competent authority of a member state who retains the status of owner of that data. And so this means that the EDPS has to cooperate very closely with the National Supervisory Authority when it comes to making a lawfulness check, when it comes to assessing the validity of a restriction. We ask the formal opinion of the Data Protection Authority, who in turn consults their competent authorities. And we're obliged to take into account their opinion in our final decision. A quick word on those decisions. So the final decision that we issue to the controller, in this case Europol, at the outcome of an investigation, this is binding. It may be accompanied if a breach is found by corrective measures, and it's challengeable before the Court of Justice by both the controller and the complainant. I want to finish by just mentioning two, let's say, broader ongoing challenges that we see currently. They're particularly pronounced in the EU Justice and Home Affairs domain, but I think they are equally applicable at national level. And the first challenge is linked to new technologies and big data. And in particular, the practice by law enforcement authorities of collecting and storing large, unstructured data sets. And we're seeing that this can pose challenges for data subjects when trying to access their data, for controllers when they need to search that data in response to an access request, and for the supervisor when they need to supervise that access. And the second challenge, which is especially, clear and coming more to the fore in the EU Justice and Home Affairs domain, is just the multiplicity of actors who are involved in collecting and exchanging operational personal data, often under different governance frameworks. And this is, and we can expect it to become even more of a challenge when interoperability framework enters into force. But it makes it harder for the data subject to identify who is processing their data, to trace the exchange of that data and get access to that data. And I'm going to stop there.
Thank you very much, Joanna. I thank all of you for your speeches. I want to finish this panel before giving the floor to the audience by coming back to something that Daniel said. He pointed out an elephant in the room by saying that law enforcement authorities were not prone to share data with data subjects in particular. It's true, except with themselves, and sometimes also abusively. As you have seen maybe in the news yesterday, the Belgian supervisory authority has issued reports where you can see that police forces sometimes have access to the data for non-adequate purposes. Something that I don't know is whether and how data subjects can have access to those recipients. It's particularly interesting because we have now a case at European level at the ECG that we should all know also the recipients of the data and also the new data controllers as officers have access to those data. So it could be a next case that we should examine later on. But thank you very much, all of you, and I'll give the floor to questions now.
A little question, if I can.
Sure. Yep.
Just a practical question, because I do a lot of litigation, but in Belgium, sometimes we have to wait more than 1 year to have an answer from the supervisory authority. In the directive, there is no delay to answer. I think there is no delay in the Europol regulation, also not for the EDPS. So in practice, what are the delay to receive an answer and to make a litigation? If you contest the decision of Europol, what are the delay by the EDPS? Just to have an idea in practice.
Yeah, no, you're correct. There isn't a set deadline on the EDPS. Internally, from the perspective of good administration, we try to follow the deadline that's set in the EU Data Protection Regulation, which is not that more than 3 months should not pass without coming into contact, informing the data subject of the progress of a complaint investigation. But in fact, the nature of EDPS investigations involving Europol can be very complex, and they involve a specific procedure, which I just explained, in terms of cooperation with the National Data Protection Authority. So just the deadline that's given from the EDPS to the National Data Protection Authority is between 1 and 3 months, and it's very rare that we get an answer much before 3 months, because it's very difficult for them they have to in turn consult their national police, which also it's very difficult for them to extract an answer. And so this really, and we've had the case where we will receive an answer from the National DPA, which is not fully coherent with the answer from the controller, where we then need to go back to the DPA, ask them to check again, and then if their answer is not in line with our findings and our investigation, there's a whole new procedure where we need to take the question to the Coordinated Supervision Committee, where it's discussed, and then so I think the specificities of these investigations they do tend to be quite lengthy. It's also a measure of how thorough we try to be when because we don't want to get an answer and say, okay, we're questioning and checking, and but it makes it it makes it long. And I mean, we've reflected internally, and that reflection's ongoing about how to streamline those procedures, because it's an issue, it's a barrier to the right of access. I mean, it's not ideal, and in the meantime, people are in limbo. They're waiting for answers from us, and it's also not a comfortable position for us to be in. So it's
What is interesting also, that something that I learned is that the EDPS decision is binding in say, which is not something that is written in the LED directive. But I don't think there is something that says that the decisions of the DPA must be binding in that domain. Also, what is interesting in the EDPS system is, as I understand, that they can file a complaint against the decision of the national authority, but they can alternatively also do an indirect access request. This is also something really interesting, because when you read the system in the LED directive, it is not so clear. It is not that clear that it is both direct access and indirect access. In most of the countries, when there is an indirect access, except in the case of Belgium, where it is a systematic indirect access, we have no direct access in Belgium. When there is a system of indirect access, it is only in the case of limitations. It is not an alternative measure to the direct access. But this is something.
But that's the same.
That's the same.
Article,
Okay.
Yeah. Under Chapter 9.
Okay.
It's in the case of restrictions.
Of limitations.
That have been
Okay.
and the wording is the same for Article
Okay.
17. So
Okay.
it's a
Sorry,
so.
I thought it was a bit different. That's great. Do you have any questions in the audience for speakers?
Thank you very much for your. It's not working, I guess. But do you hear me?
Yeah.
Okay. Thank you very much for your speeches. I have a question regarding the practical impacts of. Because we're always talking about regulations, but for example, in France, some of our friends tried to have access requests, and they were rejected because they were not written as letters, and or other practical issues which hinder the right to access. Did you see any case where this was challenged? And the second question is, how do we deal with the national security exemption? Because I think it's getting broader and broader. And since the police is already using data from intelligence agencies, it puts us on unequal foot when we don't learn anything about the source of the data. So it was my second question. Thank you so much.
The French part.
Yeah, for who will answer that question?
I think many can answer, but
Yeah, of course.
but the French part, I guess. So, for the part about the national security, as far as and as far as I'm aware, I think that's a pretty big loophole, especially in Greece, for example. We placed a specific exemption regarding all the processing operations the Central Intelligence Agency in Greece conducts, which is pretty interesting, especially if you want to learn about the origin of the data, which is clearly interesting as well. Also, the law placed the Central Intelligence Agency outside the scope of the Hellenic DPA, if I'm not mistaken, regarding the processing it conducts. So it's pretty interesting concerning the inequality part. You know, you have no way to find out what happens with your data and what do they collect and why do they collect them. Yeah, it's and I think a if you ask me, my idea would be a new vertical directive specific for this reason. This could help a lot address many issues that came around, you know, lately. Now, for and just for the first question, if I understood that correctly, in Greece, for example, we have facilitated the access. So in Greece in the past, we had folders of political beliefs of individuals. That changed after 1974. However, the police has developed a whole new process of how to access those historical files. Yet, regarding the access, it's like you visit the website of an SME that it's not compliant with the GDPR. It's like, okay, send there, either via mail or via email, and we'll respond. In the past, for actions we've taken with Homo Digitalis, we did not get respond within the time frames, the required time frames. In Cyprus, however, they have developed a procedure which facilitates the access both in English and in Greek, because the aforementioned paradigms in the Hellenic police is only in Greek. So, yeah. And, I think, yes, many requests. The thing is, they were not denied. I'm skeptical if they were even processed in the first place. So the overall compliance of the Hellenic police now, it's an issue. And also the appointment of the DPO, and if the DPO meets the requirements of 37, you know, which is also important. However, we're not sure now.
Thank you very much.
Because you mentioned at the beginning the issue of formality, basically, should this come with the letter. I think this is a very important point where indeed maybe there should be more thoughts about that. In my personal view, if a citizen sits down and writes an email or writes a handwritten letter to the police and says he or she would like to have access to his data, that is already reason enough to act, and the citizen needs an answer to this. But there are practical challenges. That is, for example, the discussion that is there about has the citizen to provide an ID card. Then you have citizens that don't have a nationality anymore. So what do you accept? Do you accept then the Trump card or not? The problem is not And that's why I think it's important that these matters are dealt not by the operational units, but by the independent data protection officer. The problem is not, do I allow this and this? The problem is, if this would be given to an operational unit, they would further to investigate and say, okay, we get this first name and this last name, but we also need the postal address. And we also need to know whether to be 100% sure that the person is the one that we have in our system. We also need to know what is the name of the daughter or the son. And there I think you have to make limits. And that I think this balancing act there between formality on the one side and to address the fundamental right that the citizen has, that needs to be done by data protection officers that are trained to do this. Otherwise you come to wrong outcome, to a wrong outcome. Regarding the timing, just because you talk now about the timing of the response of the supervision to request, there and that what Joanna says is basically the same for Europol as a law enforcement authority. The processing operations get more sophisticated. There are more players involved. And the majority of the time that I said before, we have 3 months, and we try everything to comply with this 3 months. But 3 months, if you have to go through this procedure, is not a lot of time. And at Europol, the situation is we need the input from the data provider and from the member states. We cannot say, if we don't hear from you by next week, we understand you agree or you disagree. It is the legislator said Europol has to consult, full stop. So, and that's why, luckily now after the COVID time, we are strict online. Every data subject will get now an answer within the 3 months. But I also have to say that I receive sometimes phone calls from defense lawyers saying, I just sent it to you today, could you please, because my client has a national investigation, please, can you give please priority to my client, so that we don't have to wait for the 3 months, that we get it within 2 weeks or 3 weeks, and then my answer is, I'm sorry, it's not like that. You send it to Europol, you get a number, and we go then one data subject access request after the other. But indeed, also this telephone calls I receive.
Okay, so there's no reason to phone you.
Don't phone me.
Great, thank you. Is there another question? We have 3 minutes left. If someone else has a question, yeah?
Krzysztof Garstka from Trilateral Research. Thank you for a very, very interesting discussion. Truckload of very interesting information on the matter. My question is about research conducted with LEA case files. So have you ever encountered a situation where a subject access request would indirectly involve data that was shared with researchers to, for example, test various tools and so on? Has this ever happened, or is this more of a theoretical problem that personal data would be shared with a research organization, an access request would come, and then this research organization would be a third-party recipient, essentially? Is this a theoretical problem or a practical problem?
So, because of the access request, it goes to the for the testing.
So if the law enforcement body shared some data with research organizations, right? And then a subject access request comes. The authority apparently has to say that this has gone to other recipients, as we discussed.
Specific information.
Right. So has this happened ever, like this research interplay, or not really? And it's
my experience as a researcher, when you try to access police databases, you only receive statistics and anonymized data. So they will not consider that they are sharing with you any personal data. They will share with you aggregated data only. But maybe
I think it's a really interesting question, and I'm thinking in the context of the development of AI tools. which might be undertaken by a private sector contractor or a research organisation on behalf of an LEA, and there for the training of machine learning models, operational personal data could be used, and so I don't see why that would not fall under the category. That it should be that this is a recipient of the data. I mean, then it raises a question of whether that further processing is under the law enforcement framework, or is it under the GDPR, the EU DPR? But that's another discussion.
We have an article submitted on that specifically. But, thank you.
Thank you very much to all speakers. It's time now to leave this panel, but thank you all. Thank you. Thank you very much.